everybody. This is American Nana, and I'm coming to you with part two of my Shanda Vander Ark. Her name sometimes gets me. It's like, anyway, I'm coming to you with part two of her appeal. And what I plan to do on this one is at least get through the appeal. And then I will probably have another couple videos either with the trial or at least with the sentencing because, since she's bringing all this up in case people aren't aware, um, it would be nice if people saw the real her instead of this woe is me that she's pretending this self-diagnosing woman with all these medical issues now. Oh, I'm sorry, and before. So let's get right back to where we were, okay? Give me just a minute. And as far as my crafting mess, you will see it evolve into either bigger messes or become neater because I'm in the middle of doing all kinds of stuff. And that's why it's just going to be a mess unless I ever learn a blue or green screen, which I got one, but can't figure out how to use it. And I guess it was supposed to attach to my chair. I can't figure that out. So it still doesn't work if it's just on my chair. So who knows what I'm doing. So that's why I said, I'm not going to keep fighting with it anymore. I'm just going to go for it. So, um, if I ever make enough money to get a bigger house than what we have, uh, then this is where we're going to be. Excuse me, my nose is sniffy, but we've got a full house here, so it is what it is, and in all honesty, it don't bother me. It's just that I know a lot of people can be very judgmental. But I decided that I'm going to forget the judgmental and I'm going to do what I enjoy. So that's why I'm getting more serious and going to try to do it, trying to time it just right. Anyway, I hope you're enjoying this. If you have not seen anything on this woman, she is something else. And if you have, I'm sure your feelings are a lot like mine. So let's get with it. All right? Because um, I just can't help myself. We're going to watch the portion where her attorney tries to get, um, court adjourned for the day because Miss Vander Ark doesn't feel well. And I just have to play this portion again because watch her behavior. Just watch her behavior. She, needless to say, does not cease to amaze me. It's pretty blatant.
People versus Shanda Vander Ark. Mr. Ambrose, your client, was she able to get some medication or no?
No, not yet.
All right. I know there's some bureaucracy stuff that goes on between
Yeah.
the jail and.
The MBOC is the one that would dispense it since my understanding, because she's not in Muskegon County custody, that it had to go through MBOC. So I did send an email to the person in charge of the MBOC who would be the person that could authorize at least some medication.
How is her headache now?
Not good. I mean,
All right. All
Who
right, I did get a
cares?
copy of the medical records. I'm assuming
Make
that
myself
we
smaller.
don't want to make it a part of the record, at least certainly not an open part of the record. Because how do you guys want to proceed with that? I can make them a confidential part of the
I
record?
would stipulate to any sort of protective order that the defense would want on these matters.
Mr. Ambrose?
that's fine.
Okay, So I'll make them part of the record. We'll call it the court's exhibit number 1. It'll be a confidential record. Uh, The court did have a chance to review those records. It looks like on the 22nd, without going into all the details, it's like on the 22nd, Ms. Vander Ark complained of that she felt like she was going to pass out. I don't think there's any indication in these records that she did in fact pass out. There was some concern with some thyroid issues when she was eating apples, I guess. And they basically told her, don't eat apples. That's what's in the records. So there's nothing in these records about her actually losing consciousness. She reported that she was going to pass out. There's also indication that she asked for some Dramamine for the trip to Muskegon because she typically gets car sickness. So that's kind of in line with the testimony that she felt sick on the way here, but she at least indicated that she gets car sick. So unless I'm missing something, it sounds like they sent her because there was no concern. So based on the records and what we've already done here, I think she's competent and we're going to move forward today. I am concerned that she reported losing consciousness when a medical person indicates that she complained of feeling like she was losing consciousness and that she's now kind of amplified for whatever reason, I don't know. But I am concerned about that, the fact that she misrepresented that to her attorney, potentially, that she actually lost consciousness because there's no record of that. So anyway, anything else before we move on, Mr. Ambrose?
Well, the only way that, just
Watch Shanda.
she would have to report to the medical personnel that she actually did lose consciousness. So,
Well, I mean, she okay, I get it, but the quote is, quote, I felt like I was going to pass out. I have tremors that are severe. That's what she reported on the visit November 22nd, 2025 at 6:45. And she was treated. She says the administrative note was that she was advised on site that the above patient came to the clinic concerned of dizziness and a tingling throat. The tingling throat was transient and only when she ate apples. And it says the RN advised patient had a reddened throat, no swelling, no lymph node enlargement noted. And eventually the treatment is, it says she did palpate in a large thyroid. However, the patient is, I don't want to get into that. It says RN still had concerns about patient's fall risk. The RN exam otherwise unremarkable. RN gave the patient detail prior to calling. I advised RN to tell the patient to stop eating apples. Other than that, I did not have orders for this patient. So that's what happened on the 22nd, at least according to the note. Like I said, I don't know what happened, but these are medical records by individuals that I don't know if they'd have a reason to lie, quite frankly, if they're making a medical record. So based on that, I don't see a serious medical issue that is to the concern of the court. So
Look at her
anything
attitude.
else, Mr. Ambrose, on that? I mean, she can testify if
she's-
she wants about what she's going through. That's fine, but if the request is for an adjournment because of a medical issue, I don't see it. So well, I'm not. Listen, I'm not gonna delay this anymore. This is, in my opinion, Mr. Ambrose. She's misrepresented and through you to the court that she passed out. She did not pass out. So I'm moving on. I think this is gamesmanship on her part, and I'm. It's now 11 o'clock, and a hearing that we were supposed to start at 9 o'clock. The court's been very patient with this, and we need to go. So, anything else?
No, Your
Ms. Bloomquist. All right. So, Mr. Ambrose, this is your hearing.
Yeah.
You can call any opening statements on either side, or you want to just go straight into witnesses?
We can go straight into it.
All right. You can call your first witness.
That would be Mr. Johnson.
So they're calling her original attorney, who she's saying was ineffective counsel. And this man tried his best. Bless his heart. I couldn't, there's no way I could represent a monster like this. I'm not, I don't see how people do it, but this gentleman that she had as an attorney
All right, Mr.
is a
Johnson, if you
very
want to come
caring
on up front
man.
here, sir.
It really makes me angry that she's
Good morning.
attacking him.
Good morning.
All right, would you raise your right hand to be sworn?
Yes, sir.
Matter now pending. Do you swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, put your hand down and grab a seat. Please state your name for the record, spelling your first name and last name.
My name is Fred Johnson, FredJohnson.
All right. Mr. Ambrose, you're welcome to stay at the table or the
Okay.
podium, whichever you prefer. So you can,
Appreciate that.
you can stay standing, stay sitting, it's up to you, okay?
Yes, thank you. Mr. Johnson, you represented Shanda Vander Ark, is that correct?
That is correct.
Okay, and do you recall, you're an attorney.
Yes, sir.
Can you tell us when you became an attorney?
1984.
You know, and I apologize, Your Honor, before we start. Ms. Vander Ark, Mr. Johnson may be getting into some confidential information. You understand that?
Yes, sir.
And you understand that by going forward with this type of hearing, that he's going to relay some competencies.
Yes.
Are you okay with that?
Yes, sir.
Do you have any questions regarding
No, sir.
it? Okay. With that disclosure, Your Honor, I'm going to proceed with
Okay.
the examination.
Anything else we should put on the record regarding that you want, Ms. Bloom?
No, Your Honor.
Okay, all right, good enough.
What year did you become an attorney?
1984.
Okay, and where'd you go to law school?
Thomas M. Cooley.
And so from 1984, have you always practiced criminal law?
I have always practiced with law. Yes.
Okay, and has your license, have you continuously been an attorney ever since 1984?
No, sir. My license was suspended last year for 6 months.
And what was that? So it was suspended last year for 6, what was the reason why it was suspended?
Violation of confidentiality, conflict of interest rules.
Okay, and that was while you were a public defender?
Yes,
And when you represented Ms. Vander Ark, you were a public defender, is that true as well?
yes.
And the initial allegation that was lodged against you, when does that go back to?
Oh, gosh, that was, I couldn't tell the year, 5 years ago, perhaps 6.
And when was the complaint issued against you?
2024 is my guess.
Okay, and
2023 perhaps.
Did you admit to the grievance?
Yes, I did.
And what did you admit to?
I admitted that I had received information from one client while representing another client, and the person who the information I received was the victim in that case, in the second client's case.
And again, this was while you were the public defender?
Yes, sir.
When did you take on that role?
2013,
And
September.
what did your office consist of
In 2013,
throughout the years?
it grew over the years.
Okay,
We started, I think we're at 13, and by the time I left, we were in our 20s, maybe 25, 26.
okay.
And that includes staff as well.
So you mentioned that you admitted to the allegations within the grievance,
Yes, sir.
and what did you have to do as a result of your suspension?
I was suspended for 6 months, so I could not practice law. There's a fine and costs.
Were you required to take any type of classes?
Was I required to? No, I did. I was not required to. I did, but I was not required to.
What type of classes did you take?
On ethics, conflict of interest.
Okay. And did you testify at any of these hearings?
Which hearings? The ethical issues?
Yes.
Yeah. I don't know if it was testimony or not. I made a sworn statement at the time of my initial interview, and I spoke to the state bar. I think that was under oath as well, so that both my testimony.
Okay. And part of your disclosures were that you're more or less overworked. Is that accurate?
Was I overworked? I think I was.
A public defender? I bet he was. But we're going to try to throw shade on something he did years
And
ago.
would you disagree with, I was working too long, I was working too many cases, too much stuff, too many irons in the fire? Is that something that you may have said?
Yes, sir.
Any disagreement about that?
No, sir.
He agreed he was overworked.
Also, basically, when I was a public defender, I was working on a conveyor belt system. And the problem that came up on the belt next is the one I tackled and tried to keep the other ones juggling until I could fix them as well. Does that sound like something you might have said?
Yes, sir.
And
Now, this case with regard to Ms. Vander Ark, do you recall when you initially, how is the assignment system conducted in Muskegon County?
You mean back then or now?
When you were assigned?
When I was public defender?
Yes.
Okay. The attorneys are assigned to judges, and whatever case the judge received, that attorney assigned to that judge will receive that particular assignment. Normally, that was the situation, unless something came up, and then we'd have to change assignment for whatever purpose might have occurred.
Is there a private bar that receives assignments as well, or is it just everything that every indigent client goes through the public defender's office?
Things have changed over the years. Things have changed over the years. Currently, all the indigent individuals go through the public defender's office. There is a private bar, however. Are there assignments to the private bar? On occasion there are, and there were.
Upon receiving the assignment, do you recall when you would have first talked to Ms. Vander Ark?
I would assume it was before the preliminary examination, but I don't have a specific recollection of any particular dates.
At any point in time at the preliminary examination, with your initial conversation with Ms. Vander Ark, did she ever admit to any type of guilt?
No, sir.
All right. Now, she contended that she was innocent throughout this case, isn't that right?
Yes, sir.
She testified, right?
Yes, she did.
She never admitted to any type of wrongdoing that caused the death of her son.
That is correct.
Now, while you were assigned to the case, did you have Ms. Vander Ark see a professional? with regard to competency or criminal responsibility?
I happen to
I found this to be very interesting. Very interesting. She's got a lot of nerve thinking that she would have gotten a better defense attorney than what she has right here.
Vander Ark see several professionals, two doctors, and we employ social workers on our staff.
With regard to, do you recall having Ms. Vander Ark seen by Colin King, Dr. Colin King?
I do recall that.
And in Mr. King's report, did he do a report?
He did.
And do you recall what the results of that report were?
I don't recall the specific results. I recall the conversation we had in regards to that.
As part of his conclusions, would you agree or disagree that he mentioned that Ms. Vander Ark continues to insist she did nothing wrong and was not convinced that her actions and instructions caused the death of her son?
I don't recall that specifically. The other report, it might refresh my recollection, but I don't argue with that statement. It sounds, generally speaking, as what I recall.
May I proceed?
You may. Yes.
And
I'm not real
that
sure.
is, it's an accurate statement that she had stated that to this doctor that she felt that she did nothing wrong. Is that correct?
Yes, sir.
And you went to trial on that basis, right?
We went to trial because she was charged, sir.
And she proclaimed her innocence, right?
Even had she not proclaimed her innocence, we would have gone to trial as she was charged with first degree murder.
What a good answer. She went to trial because she was charged. I mean, I guess I should say, what a crazy question. The answer was fantastic.
But yes, she proclaimed her innocence from beginning to end, and we tried the matter.
Were there any offers made to Ms. Vander Ark?
None that I can recall. So,
Now, Ms. Vander Ark testified at trial, right?
correct.
And she again proclaimed her innocence to the charges, right?
That's correct.
And there was an incident on the day of her testimony where she had a physical reaction to seeing a photograph of her son. Do you recall that?
I believe that was, if we're talking about the situation where she turned and there was a trash can there and she appeared to I don't know if she actually did vomit, but she had the body language was indicating that's what was going on. I was sitting in chair with the prosecutor.
Okay, that portion of the trial, if you didn't watch it, I'm a person that is very weak stomached. And in my opinion, she was not physically ill, but she was going through the motions of being physically ill. There wasn't this sound that comes along with it, if you know what I'm saying. So that was one of her shows during trial of, oh, I'm so sick, as if seeing a photo of her son made her sick. She saw her son every day.
And during her her cross-examination was, you described the cross-examination for us.
Aggressive and effective.
Okay, aggressive and effective. And did you,
As it should be, aggressive. I love how I said aggressive and effective, though. That's perfect. But I mean, what? You're supposed to go up there with kid gloves and talk to this monster? Huh. I mean, I'm making no issue about Mr. Johnson whatsoever. He has my utmost respect. And my comments are to the attorney trying to get her a new trial because it's it's just it's unreal. That you would expect her cross-examination to be anything other than aggressive. Just my opinion, but
see Miss Vander Ark after court that day?
I don't believe I went out to the jail to see her after court that day, no.
Okay, did you go into lockup with her after court?
I can't honestly tell you that.
Right. The next day, can you tell us what happens?
oh yeah, she
If
ain't
my
coming to court
recollection is
again.
correct, the next day, court was resumed and, my client, Sandra, was unable to attend. She was unable to come to the hearing, as I recall.
And
She refused.
you reported that to the court, right?
Yes, sir.
And you stated to the court that she had some competency issues at that point, is that correct?
Some competency?
That she wasn't able to proceed.
Yes, and, yes, sir.
May I approach you?
What she was doing was putting on a show because she
And this
knew
is, I'm showing you a
she was losing.
transcript of December 15th, 2023. It's on page 3. If you can just read that portion.
Yeah, she's a good actress, or she thinks she is. But I mean, obviously, if I'm assuming if anybody was sitting in that courtroom, they would have been able to read the jury. In which case,
Yes, sir.
she knew she was
And so you
toast.
indicated to the court that she wasn't competent to proceed, is that right?
That is the word I use, sir.
Okay. And describe to us what she was going through.
She was, when I went to visit her, she was curled up in a ball on the floor. She was crying, she was upset.
The audio changed, not me.
She expressed that she couldn't return to court. She expressed that she was upset, that she was stressed, that she was experiencing, and I'm sorry, I forget the word. She experienced a period of where she's so emotional she can't function intellectually.
Oh, she was afraid that
And
the jury was going to ask her
based upon that,
questions.
you reported that to the court.
Yes, sir.
And you also, do you recall reporting to the court as well as that if we waited until, or adjourned the matter until Monday, Tuesday, or Wednesday of the following week, we'd be in the same situation?
I don't recall, but I'm not arguing that I assume you have transcripts there.
That would have
I
been a
recall
smart
saying
thing
that,
to
but-
assume. Yeah,
If you look on page 4,
of
It's
course.
fair, sir.
She was going to act
the
that way
second
no matter
full
what.
paragraph,
Okay,
starting with the
She knew her
word
goose was
1.
cooked.
okay.
So because she played all emotional and stress,
And you agree that you told the court, we couldn't
sorry,
guarantee to the court that as of Monday or Tuesday or even Wednesday of next week, we'd be in any different situation than we are right now.
That is what I said.
And was that an accurate assessment?
That was my assessment at the time, yes, sir.
and everybody else is she wasn't coming back in.
Do you, okay, so
The jury would have been able to ask her questions that day. That's where they were.
one of the things that you argued to the, or suggested to the jury was that Ms. Vander Ark was guilty of manslaughter. Is that right?
That she was guilty of manslaughter.
Yes.
I don't know if I used that term. I don't recall arguing on the manslaughter issue. Can you tell me which page?
Yes. I have this broken up, but it's on page 84.
Okay. Do I have it?
Yes, in the back.
Okay.
So in this courtroom, they get to ask questions. The jury does, and Shanda didn't want to answer any.
It's actually on the very last page, page 89.
Oh,
So I'm
First
sure
full-
that had a lot to
first
do
full
with her
paragraph.
emotional issue.
And you told the jury, these people, and I'm assuming you meant Paul as well, these people committed manslaughter. That's what they did.
yes, sir.
They caused the boy's death.
Yes, sir.
The facts prove that.
Now, Ms. Vander Ark never gave you consent to say that she was guilty of anything, did she?
No, sir.
And so you kind of took it upon yourself to make that argument to the jury.
Yes, sir.
Ask your next question for Pete's sake. Oh, he reminds me of Lally. He's so slow. That was it? Ah. Okay.
Good morning, Mr. Johnson. How are you?
I'm well, thank you.
Now
So
let's get
I'm
the
just going to
facts.
go back a little bit more into your experience. So how many years have you been a practicing attorney?
41 this year.
And how many years of that as the chief public defender for Muskegon County?
From 2013 to 2024, so 11 years.
Is it fair to say in your role as the chief public defender, you would take some of the more severe cases that the county has seen?
Yes, sir.
Oh.
Yes, ma'am. My apologies.
That's okay.
I'm on the roll.
Now, just sort of getting into some of the comments that were brought out from your sworn statement or things like that, there's discussions about your workload. Do you recall that? And maybe feeling like you had a conveyor belt system.
Yes, ma'am.
Did a case like this fall into the same category of cases you were discussing in that?
No, the cases like this get the spotlight. They come out of the group of the pack, and we place not only my efforts, but the social workers and other attorneys on staff. We all work on cases of this magnitude.
Okay. So although there's testimony by you to the effect of being overworked and that impacting some of your cases, is that an accurate sort of representation of what's said?
It certainly impacted the one where I saw that information. I should have seen it. It impacted there. That's why I think. Yeah. But I'm sorry. Go ahead.
No, and that's okay. And just to be very clear, the case for which you had your suspension had absolutely nothing to do with this case, correct?
That's correct.
No witnesses between, Paul and Ms. Vander Ark. That wasn't the conflict at issue.
That's correct.
Okay, it was a wholly unrelated matter.
Yes, ma'am.
And, while we're on that topic, did you have to sit in that exact same witness chair and again, they're hearing on that case as well?
Yes, ma'am.
Okay. And you testified about the allegations and the conflict that was alleged?
Yes, ma'am.
So getting back into your prep on this case specifically, let's walk the court through your preparation for trial. Let's start with prelim. Walk us through your preparation for preliminary examination on this case.
Well, I assume all lawyers do. You receive information called discovery, and you pour over it. You go out and see your client, you talk to your client about what's going on and what her impressions are. You come back and you go over it again. You bring in other attorneys to take a look at issues. You run issues back by them, see if they have any similar experiences or any pointers that they may want to bring to bear. You bring another attorney in, usually a younger attorney, to sit and to watch the whole process. We also employ interns here. So the beauty of interns is, whereas I may have multiple cases, they only have the one, and they pour over the documents and the materials. And if there's anything in there that they see, then they can bring it to my attention. But it's a fallback situation, so we can bring other eyes on it. And there was no different than here, Ms. Vander Ark. We did all these things. We worked dozens of hours just for the preliminary examinations, and we were ready to go.
So it sounds like you created a team, so to speak, for Ms. Vander Ark.
Yes, ma'am.
How many people would you say were on that team?
Over time, coming and going. Over time, from the time we got the case to the time we ended, maybe 4 lawyers, an investigator, 2 or 3 social workers, so we're up to 9, and half a dozen interns, so about 15, 16, something like that.
So 15 or 16 people working on her case specifically.
Over the course of time, yes.
Okay. And as part of your preparation for trial, now let's shift to preparation for trial. You talked about hours for preliminary examination. Could you describe?
At this point, we've had time, a year, to look at this thing. We've brought in experts to examine my client. We've gone out to the scene of the crime and taken photographs and walked around, got the feel of the place. We've talked to multiple folks who we were considering experts, but we ultimately didn't hire. We spoke to outside social workers to see if any of them had come across any episodes along the similar line. We even saw an article in People magazine about a woman throwing her kids out the window and then jumped herself. And quite frankly, it was eerily similar. And I'm still, this is something to do with what my client's conduct. But it was hundreds of hours by the and I'll put in a couple hundred hours myself on it, and then you add in what everybody else is doing. It's a lot of time. It's a lot of effort. And I told her, I think if she had to hire, she'd spend $1 million on what we did for her in terms of trying to prepare and defend her in this case.
So just so I'm clear, you yourself dedicated hundreds of hours
Yes, ma'am.
personally to this case.
Yes, ma'am. It was either I'm reading something, or I'm talking to somebody, I'm looking for this needle in the haystack. I believe that, I believe now there's something wrong with my client, and that there's somebody out there. And
You sought out experts, correct?
yes, ma'am.
And were some of your experts from the Center for Forensic Psychiatry? The sort of state-run.
We use the appellate defender has a website, and they have a listing of witnesses, expert witnesses that other lawyers have used, and we use their list in determining which one's their approach. We also use here from the other lawyers in the office. Have you used anyone in this circumstance? Do you know of anyone? And those are the lists we use.
Okay. And so I know the record will reflect this, but I want to ask you, do you recall having a criminal responsibility report done for Ms. Vander Ark?
Yes, Dr. Watson.
And do you recall also having a criminal competency report done as well?
Yes, ma'am.
And now those were ones that I believe were filed with the court, correct?
Yes, ma'am.
Were there reports that you, or examinations that were done and reports that were drafted that were not filed with the court on Ms. Vander Ark's behalf?
I don't know if we filed Dr. King's report or not. I don't think we did.
Okay. And did you also get a report from a George Watson Jr.?
Yes,
Okay, and to your knowledge, was that ever provided to any, to the court or to the parties?
my recollection, no.
Okay. Is it fair to say that you did a lot of investigation into experts who could testify about her mental state?
I think that is fair.
Why didn't you present those experts?
The conclusions the experts provided would have been supportive of a verdict of guilty of murder. Their positions were uniformly and enthusiastically negative towards my clients. They would have been prosecution witnesses and presented their findings.
So you intentionally did not call these
That
experts?
is correct. We intentionally did not call them.
And that choice was made after a thorough investigation of their opinions, correct? Or I guess explain the investigation that went into that determination.
Dr. King, for instance, when I spoke to him, his response was, "She's a monster." His response was, "She's the worst thing he'd ever seen." And he's a man who testified for mass murders. I did not want to bring his testimony. Dr. King simply said that she was competent at the time. She was competent for trial. And
Can you imagine that? Can you imagine getting doctors that testify for mass murderers and they actually call your client a monster? You know, I hope this is not, oh no. Oh no. I hope it's not going in and out on y'all's end. My screen keeps going black. I don't know why it's doing that. It's just when I'm using StreamYard, it seems, and my camera. It's really weird. My cords or something. I don't know. I'm just going to hope it doesn't happen to you guys. So I just had to say that because I can't even imagine, you know, he's being told by these doctors she's a monster. In other words, yeah, Betty, she did it. I mean, I'm not saying they said those words exactly, but yeah, she's a monster. And you know what's funny is when referred to her as a monster, it had not even dawned on me that they did. So, but that's to me is what she is. It's just a monster. All right, let's go back. I'm so sorry.
that's not what I want the jury to hear. I want the jury to hear there's something wrong with her.
So let's get into, and I hate to zoom out here from these details, but what was your overall strategy?
The overall strategy was to attack the issue of premeditation, that my client premeditated when she caused the death of this young man. Our strategy was to demonstrate that through, especially her text messages, that she was, for whatever reason, unaware that her son was suffering and was close to death. And we tried, especially with her text messaging at the time, to demonstrate that that was the case.
And I know you previously said you were looking for a needle in a haystack for something in your defense, correct?
We were looking for the cause. If you understand the facts involved in this case, this young man was her son. This young man, she could have refused. She could have refused even to take him into her home. She brought him into her home to care for her. This young man was killed in the most brutal, heinous way that you can imagine, slowly starving him to death. The two, and it probably is just because that's the way I just can't believe that a healthy person would have done the things that she did. I don't believe to this day.
Now,
This
the
is hard.
realities of this case and the nature of it is something you have to factor in your preparation, correct?
Yes, ma'am.
And you did, in
Yes.
fact, do that?
Yes, ma'am. The evidence? Yes.
And now you've talked about these hundreds of hours. Have you also, in preparation for this trial, did you engage in witness preparation
Of my client?
of anybody?
Yes, we talked to my client about her role and how we were going to decide once we got there. If she's going to testify and the sorts of things she might be asking, the sorts of things that we'd be asking of her. Our only other witnesses would have been the experts had they been called. And so there wasn't anyone, or the social workers. And since we didn't call any of
And additionally, in preparation, did you evaluate filing motions to suppress or other sort of pretrial motions
Yes.
on this case?
Certainly, and that was the value of the group thing. You have several lawyers and you're asking them, and an investigator, what about this issue? What about that issue? Should we file a motion on it? Should we attempt to take it to court of appeals if we lose, that sort of thing? All those issues were discussed.
Did you also prepare for your voir dire in this case?
Yes,
Okay. Are you aware there's an allegation that you did not prepare for voir dire in this case?
yes,
Okay. And in preparation for today's hearing, did you provide to me some documentation from your file regarding your voir dire?
I did.
Okay.
Yeah, Shanda's got a lot of nerve, doesn't she?
Your Honor, would you like the people to be numbers or letters given today's proceeding?
Let's do numbers. We'll stick with consistency, unless someone
Probably-
like exhibits. But
Probably the only attorney that would have
I'm
taken her
going to be
case.
showing, may I approach?
You may.
All right, I'm showing the witness what's been marked as people's proposed exhibit 1. Would you identify what this is for the record?
Yes, this is my standard voir dire sheet, in which 4 pages of questions that I may or may not be asking, depending on the nature of the case. But certain things that I want to make sure I cover and ask the juror or potential juror before they're seated.
Okay. Do you recall if you used this preparatory document in your trial?
Yes, I did.
Okay. And I know this is a blank version, but did you take notes on it during the trial? Or
Yes, I did.
Your Honor, at this point in time, I'd move for the admission of people's exhibit 1.
Mr. Andrews?
I'm sorry.
There's been a movement for admission.
Oh,
of
I
exhibit.
okay.
All right, so exhibit 1 is
You can
admitted.
just leave that.
Objection.
What did you do to prepare for voir dire? Was it all contained in this document, or what else did you do?
No, ma'am. The day before, a couple days before a jury trial, the list of potential jurors are made available to the parties. We got that list, and there's some information. Used to be better was handled, but now the computer stuff is not as helpful. But there is information, and I say myself and the interns go over this information to discuss potential jurors. We're looking for folks that we want to keep on the jury and folks we don't want on there, and so we're going over these things and we're asking questions back and forth. Do you know these people? Have you met these people? Are these people, are they friendly to us? Will they be hostile to us? And we're going over that list. And so we've got notes. When we come into court, we have notes on the witness list they gave us as to individuals we may not be called, we may not wish to have on the jury. A police officer. If there's a police officer, we're probably not asking to her. So we go over that. Then when we get to when we prepare, we're looking at which of these questions are important to us and which ones are not. The way voir dire works, as you know, they're asked, did you hear all the questions and we can't answer any different. So you can't ask the same questions over and over. So what I try to do during my voir dire is specifically save out some questions so that every time I take somebody out, I have new questions for them. The whole panel hears them, but they're new questions and they kind of help keep the interest of the rest of the panel. So that's part of the voir dire preparation. The reality with voir dire is if you pick a bad jury, the case is over. You're done. You've got to emphasize that part, because if the jury's not listening to you, it doesn't matter how brilliant you are afterwards. The voir dire has to be effective for your client. So we put a lot of emphasis on it.
And you specifically did in this case.
I specifically did this case.
Now, is also part of your voir dire come from experience?
Yes, ma'am.
And could you give a rough estimate before this trial how many jury trials you have conducted?
Misdemeanor, misdemeanor and felony, maybe 2 or 3 a year, felonies, and back when before I became a public defender, 10 or 15 misdemeanor cases, literally a couple hundred. I don't know. I lost track a long time ago.
You don't keep a sheet with?
Yeah, at least 10, 15 a year for 30 years. So
Okay, thank you. But you have vast experience in selecting a jury, correct?
I've done it many, many times.
And is part of selecting a jury knowing potential jurors out in the gallery that might be called up if you excuse somebody?
Yes, ma'am.
And I guess, do you see your obligation as a defense attorney to make sure you use every preempt, or to make sure you get the best jurors seated in those seats?
I want the best panel. And I tell my folks, the young folks, it's not how many questions you ask the right questions. You don't need to ask 100 questions. So there are occasions where my voir dire may be brief, but hopefully it's effective. And I'm talking, and as Judge Casey will say, I talk loud. Everyone in the courtroom can hear me when I'm doing my voir dire. I speak to the people out the back as well as in the panel. So yes, I'm aware of the panel here, but I'm also aware of who's sitting out there in the jury. Sometimes taking a person off the jury doesn't mean you're going to replace them with someone better. That's the Detroit Lions philosophy. Just because you replace somebody doesn't mean they're going to be better. sometimes once you got the best you have, you stop talking.
Did you feel like you had a good panel in this case when you concluded voir dire?
Every lawyer says, I want a fair jury. We don't. We want a jury that's going to do what we want. I want a jury that's going to say I'm guilty. I got a jury as close to that as I was going to get in this end.
So I'd like to shift a little bit and move into your interactions with the defendant. Do you recall, and it can be approximate, how many times you met with her personally?
Gracious, no. I couldn't meet with her. Well, okay, me personally. Gosh. No, it was, I tried to go at least every other month, so we had a year, maybe 6 times, maybe. And then during trial, and then after trial, and then are you counting the time after trial when I went to Jackson?
Well, let's
Or just before trial?
say before trial,
Okay.
but then I'll get into the Jackson.
Half dozen, somewhere between 6 and 10, something like that.
And that was while she was lodged at the Muskegon County Jail?
That is correct.
Okay. How did those meetings go? What was the general atmosphere?
The meetings went very well, notwithstanding what she was convicted of. Ms. Vander Ark was a wonderful client. She was a client from heaven. She taught. Her conversations were on point. She used time well. She didn't keep me after the point of the visit was over. She asked a question. She responded well. We have a wonderful attorney-client relationship.
And so it sounds like she was a cooperative
Oh,
client.
absolutely, always.
And she had, would you say, above average understanding of the proceedings and what was coming with the trial?
She's a lawyer. She went to law school. She graduated from law school. She has one question on her bar examination. She clerked for 2 judges. She ran on a dozen felony murder cases, sat in and watched them. So she had as much experience with the law as somebody who has never practiced could possibly have. She was, and our interactions were tailored towards that. It's not one cookie cutter for every client. Her situation was different. She stand and facts and circumstances. I appreciate it.
And in those discussions with her, is it fair to say you discussed trial strategy with her?
Yes.
Okay, what was that trial strategy?
The trial strategy initially, and hopefully when we began, was to find that there was no intention, there was no premeditation, and that there was something mentally wrong with the person that committed this offense. Quite frankly, and as I would tell my folks when I first met them, in the first 6, 7 months we worked on this, I would tell them there must be somebody else living in that head along with her. The person who did these things, they just didn't. And so our hope was that somebody who could put this was what's wrong with her. When that group didn't bear fruit, we moved to, okay, when did she perform? When did she create the intention to even injure her son? Because our argument was she never formed it.
Did you discuss manslaughter with her?
Yes, manslaughter, murder in second degree, all the homicide crimes we discussed each and every one.
And you read portions of your closing argument.
Yes, ma'am.
And did you discuss with her about conceding manslaughter in your closing?
I don't remember that.
Okay. Why did you concede manslaughter?
The volume of evidence and the type of evidence was massive. And if you look at a jury and you tell them nothing's wrong, somebody has made attention that something wrong happened, you lose them. And when you lose credibility with the jury, they never listen to what you have to say for that. Quite frankly, I was hoping for murder too. I told them manslaughter because that would give them the space to move up. But I was hoping that they would see me as a fair dealer, as an honest person who looked them in the eye and told them, this is what's going on. I'm going to try to lie to a lawyer. Your tricks and 40 of the gun, that glove doesn't fit, it must have quit that stuff. I'm an honest guy. This is what I honestly think, and this is what you should think. So I had to concede something because, quite frankly, the evidence was overwhelming, and the prosecutor hadn't even put in his best evidence.
And at the time of closing argument, is it fair to say that Ms. Vander Ark was not assisting you in your closing argument, given her mental or physical state in the jail?
We had, before the day that morning, we had stopped talking about what we were doing in court, and it was just conversations, will you come to court? That's all we talked about. Will you come to court? And when she couldn't, then we went back to court and we finished up. We had talked about the things I would say, generally speaking, during representation of her. But art form is in science, I don't know exactly what I'm going to say every time, so I couldn't tell her exactly. She understood the plan. Did she know exactly what I was going to say? No, because I didn't know exactly what I was going to say.
But I want to just clarify though, your decision to concede manslaughter wasn't an off the cuff decision.
Oh, no, it wasn't. No, it wasn't.
And you conducted some investigation and you put a lot of thought into doing that, correct?
Yes.
Okay.
Now, what he said there makes 100% sense to me. Does it to anybody else? I mean, did she honestly expect him to stand up there and say she was not guilty of anything? This woman has sat and bragged about her intelligence every which way you can brag about it. She just gets, I don't know, she just gets, you can tell she's completely ready to talk about herself and her achievements at any given chance. She passed the bar with only missing one question. And everybody has heard that bar exam is very difficult. And a lot of times people have to take it a few times before they pass. So she can't help but pat herself on her back. Even when you listen to her son Paul speak, he's got her education down very well. And I believe the reason is because she probably made sure he had it down very well, right? Because after all, she wants to toot her own horn. She wants everyone to know that she's this brilliant mind. Yet she expects those same people to think she had no idea she was harming this child. And that is just, you can't be farther from the truth. She knows what she's doing. The problem is she thinks she can pull the wool over people's eyes, and it's not going to work. It's just not going to work. There is no wool thick enough for people to not see through it. And, I just keep thinking it's just too bad that her punishment can't at least have a little bit of what she did to Timothy done to her. But I mean, I know we don't do inhumane things to people, so she's safe from that. And I wonder, I just have to say this, I wonder how the women in prison feel towards her, because I've heard some women speaking about mothers, women in prison, and many of them are mothers. And the one thing that they miss more than anything in this world is being with their children. And so when someone comes in that has harmed a child, I think prison justice is something that's on all of their minds. So I just wonder how she's doing with this. But this attorney is an excellent, caring man. I'm sure that he will forever have nightmares from all of the information he has on this case. So let's just see what else. I'm so sorry. I had to stop just to share my opinion.
So I want to shift gears here into her competency. How many cases have you handled where someone has been referred for competency or criminal responsibility examinations?
3 or 4 years, so 34.
Okay. And so have you had situations where you have somebody who absolutely can assist you in any aspect of the court proceeding?
Yes,
Was that the case in this case?
no,
Okay. And during trial, was Ms. Vander Ark alert to her being Ms. Vander Ark?
yes,
Was she alert to, she was in Judge Casel's courtroom?
yes,
And that it was the date and time that it was that year?
yes,
Okay. And she was actively assisting you, it sounds like?
she was.
Okay. And was she assisting by writing notes while you were at counsel table?
Yes, and that was my, what I do is I can't listen to the witness chair and my client at the same time. So I give them a pad and pen and ask them to write notes. Just like
And without getting necessarily into what she was writing, was the content of what she was writing coherent?
yes,
It was attuned to time and place?
yes,
It was appropriate for what was going on in the courtroom?
yes.
So let's talk about Thursday after she testified. Now, you don't recall if you went into the holding cell or the jail with her after the testimony concluded?
Okay, let's make sure I understand.
Yes.
When trial was over, did I go into the jail?
Thank you for clarifying. That was a poorly worded question. When the proceedings on Thursday, not the last day, but the day she concluded examination, did you go to the jail to meet with her?
I believe I saw her in the holding cell, which is back here behind the jury room. I think after each day, myself and the social worker involved, we go back and talk to her for a few minutes, but then we break. That was the plan. Did it always happen every day? I don't remember. I think we did most days. I don't know if we did that day.
So you wouldn't be able to say how she was appearing outside of the courtroom after that?
I have no recollection of her after she walked out of the court that day. Then I don't recall.
So let's move into that Friday morning
Yes,
that
ma'am.
you've already testified about. And you described that she was in a holding cell, correct?
Yes, ma'am.
Do you recall who was in the holding cell with you?
My Vander Ark and my caseworker. Who's my caseworker? My social worker was there. I'm trying to remember which one it was. No, I don't remember which one.
Would it be Melinda Katecki?
Yes, that was one.
Do you remember a couple of jail deputies also being there?
They were in the area, but they weren't in the cell. There's a cell area. They stand outside of that. They weren't in the cell.
Okay, so to your recollection, it was you, Ms. Katecki, and your client.
That's my recollection.
Okay. And you indicated that she was on the ground curled up.
She's on the floor, curled up against the wall.
Okay. And could you tell the court what your conversation is with her, like at the start of that morning, when you first walk
Okay.
in? What's the conversation?
Are you okay? What's going on? Can I get you something? Are you okay? What are you feeling? Can you explain to me what's going on? What was the situation? Ms. Kotecki was also talking for the same sorts of questions. What's wrong?
And what did Ms. Vander Ark reply?
Effectively, I can't quote her. She said her response was that she could no longer, she could not go up in the courtroom today. She couldn't take the trial today. She was having an episode and she just couldn't tolerate being in the courtroom today.
And at some point you come up to the trial court and you place on the record what occurred, correct? And in that you stated you discussed Ms. Vander Ark's options, correct?
Yes,
Did you in fact discuss her options on how to proceed that morning?
yes, yes, ma'am.
Could you explain that conversation to the court?
We explained to her that option one was to come back in the court and just sit there. We're not going to stand again today, just sit there. Option two was for us to go back and ask the judge to adjourn. That was in fact plan A, to ask for an adjournment for give her, or at least some breathing spell. When this happened a time previously, the judge gave her 5 minutes, but we already had an hour or so on this thing. So that was plan B. Plan C was to continue to represent her. If the judge said go, we're going to go.
Did Ms. Vander Ark want the adjournment?
Yes.
Did she want, and if the adjournment wasn't available, I guess, did you discuss waiving her right to be present at court?
I don't think, I don't recall. I don't think I did. I don't think I told her that she had a right to.
If she signed an affidavit saying that she is voluntarily choosing not to come to
Oh,
court, would that refresh your recollection?
It does, you're correct.
Okay.
She did sign that affidavit.
Okay. And did you know that was happening, or were you aware that that was something that was being drafted for her to
Yes,
sign?
yes, I did.
Okay. And so does that refresh your recollection about the conversation?
Yes, it does.
Okay.
Yeah.
Now that your recollection's refreshed, do you recall explaining to her her ability to waive her presence.
Yes, I remember, in the context of the affidavit, I think we came up and came downstairs a couple of times. And when we came down and said, this is what's going to happen, you have this, if you don't want to be there, you have to let us know, and she signed an affidavit.
Did you coerce her in any way not to come to court? Okay. Did you want her to come to court?
Yes.
Would that have been better for your case if she came to court?
It would have been better, yes, ma'am.
Did you feel like she understood what was happening to sign that affidavit,
Yes, ma'am.
or at least to make the choice to not come to court?
Yes, ma'am.
I apologize, I shuffled my notes here. Now, when you were asked about using the word competency, I believe it was on page 3 of that transcript you have there, you said, well, that's the word I used. Could you explain your response to that question?
That I used it in the layman's vernacular as competency, not as in the legal standard as competency. I didn't mean that she, as lawyers know, that she couldn't participate or that she couldn't understand. I meant as a layman would use the word competency. She just wasn't ready to go. She wasn't able to write me those notes or whisper in my ear or to participate as I would want her to have. Her life's on the line. It's a murder trial. I want her to be fully able, I'm going to say competent again, to participate in the process. This is her chance. This is her chance. And I didn't want her to leave that courtroom thinking that she left cards on the table or whatever the expression might be.
So it was not your impression that she was legally incompetent the morning of that Friday morning?
That is correct.
Now, had Ms. Vander Ark, and I know the court's referenced this before, but Ms. Vander Ark had had episodes before, correct?
In my presence, she had, if we're not talking about when she saw the photograph, in my presence, she had one episode, but she expressed to me during the course of our representation that she had others.
Okay. And one of those episodes, and correct me if I'm wrong, but you observed the episode at the preliminary examination where her co-defendant was called to the stand and she had an episode, correct?
I don't remember the timing. She had the episode of the freedom.
It'll speak for itself about
Yes,
when.
ma'am.
Shifting gears a little bit. Now, it wasn't your strategy to discuss hydration in depth, was it?
Was it my decision?
Dehydration and
No.
okay. Why didn't you focus on dehydration?
It seemed to me that dehydration, along with the corporal punishments, along with deprivation of food, along with all the other burdens that young man had to go through, were part and parcel of the same issue. Our argument was she did not form the intent to injure this child. So whether she injured him with dehydration or she injured him by starving or she injured him by thermal, it wasn't an issue. The issue is, did she intend? Did she know? Did she create the intention in her mind to hurt this boy? And that was the issue. So I didn't concentrate on the other issues that the coroner said went into causing his death either, because they just weren't the issue I wanted this jury to concentrate on.
Okay. So that was a conscientious choice on your part.
Sure, we weren't arguing that one was dehydrated. We weren't arguing that he passed away. That he was under effect. We weren't arguing any of that. We were arguing intention.
Do you think if you would have argued that he didn't have his water access restricted, that would have furthered your strategy at all, or presented the case in a better light for you?
I think I would have lost the jury on that. They had photographs of this boy, and nobody's going to take a look at those pictures and say this boy needs water.
Smart man. Smart man.
Now, there's been a claim that you provided deficient performance for allowing commentary in lieu of a video. Are you aware of the video that I'm mentioning?
Yes. The
Okay.
best thing I did in that trial was the best thing that happened in that trial was the fact that video didn't come in. That video is literally the worst thing I've ever seen. There is no commentary that can express to a jury how bad that video is. The commentary was by leaps and bounds better for our client in showing that jury that video. I'm so pleased and grateful that the people did not push to admit it. That video is just awful. And to the day I died, that was the right strategy. It's the best thing we did during trial was keep that video out. It is just awful. You see it, you'll never forget it.
And just to go back a little bit and expand this, were there in-chambers discussions between yourself, Mr. Roberts from the prosecution, and the court about this specific video and the presentation of it to the jurors?
Yes, ma'am.
Okay, could you just sort of place on the record the summary of that in-chambers?
My position was that the video was so prejudicial that nobody who saw it could unsee it and not give it, and not absolutely close it. It's just, it was, and given the weight of all the other information that Mr. Robertson presented, it was duplicative, and therefore we shouldn't allow it. That was my argument. Ultimately, as I recall, Mr. Roberts just agreed not to use it. We use this description, but we wouldn't use the actual data.
Okay, so I'm sorry, I'm not the smoothest at stopping and starting a video. The video, her complaint, she's complaining that they didn't allow the jurors to see a video that, as this gentleman says, once you see it, you cannot unsee it. And basically, had they seen that video, it would have probably taken them 10 minutes in the jury room. They would have, and let alone be traumatized, because the police officer was describing, she didn't realize, I mean, she knows what video they're talking about, but the video that they're talking about was a camera that actually had one of those cards in it that they were able to pull out, and that's the only reason they had that video. And it is of when she goes in and this baby is laying on the floor, and the way he's breathing, I guess, ticked her off. So she held his nose, so he had to breathe through his mouth, or vice versa. I mean, she and you know, this is when he's almost past. He's in that stage of, yeah, no. Um, and we know she's not crazy, but and we know she's the brightest bulb in the entire world, but that is the most idiotic argument ever, is that they should have seen that video. This attorney did the right thing. Um, the poor officer that described it, basically, it was horrific. It just was her. Oh, and I believe it showed her pulling him in there. I mean, it was just a horrible, horrible what this child went through, and the fact that they had to even see a portion of it, of his treatment right before he passed. So I don't know why she's griping about that, but all right, Miss Shanda.
But that was due to a strategic stipulation, correct?
Yeah, that was big. That was one of the best things we did.
And it wasn't an oversight that you just let hearsay in.
Oh, no, ma'am. That was a relief.
I can just have one moment. All right. Thank you, Mr. Johnson. I have no further questions.
Thank you.
All right, Mr. Nimbers. Any follow?
You mentioned that the morning of December 15th, 2023, Ms. Vander Ark was on the floor, curled up.
That's the day when she refused to, when she declined to come to court? That you talking about, counsel?
Yes.
Yes, sir. That's how I found it.
And
Refused was the right word.
you did, you used the word competent, but you stated that you were using it to the court as part of a, in layman's terms rather than a legal definition.
That's correct.
After the trial in this case, do you recall providing any interviews with the media?
I believe they were standing in the corridor,
Okay.
and I believe they did speak to me.
Do you recall telling when asked a question about your conversations with, or your interactions with Ms. Vander Ark, that she was in a catatonic state.
I may use that term, yes.
And so that's kind of a serious situation, right?
Yes, sir, it is.
And that's more or less what you reported to the court, is that correct?
Catatonic state is a more egregious, is a higher level of incapacity than I report to the court. And that's what I report to the media.
Yeah, there was some testimony regarding dehydration, and it was your decision. Was it trial strategy that you did not use dehydration as a way to explain the death of Timothy?
Was it?
This attorney's an idiot, right?
Yes, sir. The trial, would you like me to, the answer to the question, the trial strategy was not to try to explain that there was food in the house. There was water made available. The other children had corporal punishments as well. The decision was not to try to explain that these were causes of death. The decision was to explain that my client never intended this outcome. Is that?
Was there, to your understanding, was there any restriction on water
For
Timothy?
no, not.
And when's the last time you saw the death certificate?
I would have seen it before trial. Better than the last time.
May I approach the witness?
To me.
This was, it looks like it was People's Exhibit number 45 introduced at trial. Is that what you recall as being the death certificate?
I don't have any personal recollection, but this is the death certificate that they've done in this matter.
Okay, and what's the first thing that's listed
Okay.
as being the cause of death?
Okay. What box is that in? You know what?
36,
Okay.
near the bottom.
Okay, 36. Dehydration and extreme emaciation.
Okay, and dehydration would be lack of fluids, right?
Yes, as far as I know.
And like you said, there was no restriction on water in the household.
That's what my understanding was. I wasn't in the household, so I don't know if it was or not, but that was my understanding.
Well, obviously
All right,
not.
What goes to the question?
I could just ask a brief follow-up.
Yeah, go ahead.
So, Mr. Johnson, if you had focused on dehydration, would that open avenues to the prosecution to enhance some of their arguments,
Oh,
I would
yeah.
assume-
such as the fact that he didn't have access to water when he was locked in the closet, correct?
I didn't want to get into that.
That he did have access to water in the ice baths, arguably.
That's what I was afraid he'd say.
And ultimately, and unfortunately, but by the defendant's actions, Timothy was so malnourished and unable to move that he could not get himself water. Would that be accurate?
I would assume that's at the end. I'm sure that's what the case was.
So there's multiple arguments and pitfalls if you were to take that strategy, correct?
If I would have attempted to argue that whatever in here did not cause the death, I opened the door for Mr. Roberts to show that, okay, it did, and that this wasn't an issue. And I didn't want the jury to hear more of that. I wanted them to hear that my client just didn't hear. That was the message.
Thank you.
Any thought on that, Mr. Ambrose?
I know you're right. Thank you.
Okay. Mr. Johnson?
All right. So that was the attorney. So because Shanda is pulling her woe is me, I'm whatever her makeup excuse is, headache, not feeling well, just can't think, even though she's sitting there shaking her head, no, making these ridiculous faces as though she's just disgusted with everything that anybody says that she disagrees with. She just wasn't able to actually testify that day. Bless her. So the prosecution was able to start calling their witnesses pretty soon. I can't remember if the I can't remember if Shanda had more people testify about anything, but there was just nothing really great about it. But I did want to show her attorney because this man sat on that stand and he answered every question honestly. And when you listen to his reasoning for why he did or did not do something, you know that it would make perfect sense to her since she's such a brilliant mind. The problem is that she lost and she was found guilty. Had she won, obviously she would have been just thrilled. But because she lost, now we're going to go with this, you know, uh, 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 she wasn't competent to help her attorney, which he's already put that to rest, and that I guess he was um, not providing a good defense. So this judge has her number, as do most people watching it, and he's all but called her out. And that poor attorney, he said, Mr. Johnson, when they said when they were talking about the morning that she wouldn't come to court, and instead of saying couldn't, it's not that she couldn't come to court. Basically, we all know that she didn't want to. She refused, and Mr. Johnson actually said refused, and then changed his wording. But it was just so funny because what would have happened had she come to court that morning? In this courtroom, jurors are allowed to ask questions, as is the judge. The judge will question people as well. And so she knew what was coming. She knew that the jurors were going to be able to question her. She knew the judge may actually have questions for her. And she wasn't coming in that courtroom. And you can't put it off forever. And so, Mr. Johnson was right in saying that he couldn't say if there would be anything different in the future, Monday, Tuesday, Wednesday, whatever days. So, and it really wouldn't have mattered. This judge wasn't going to sit there and delay this any longer. He was on to her tricks and her feigned sicknesses and everything else. And it's like I've heard something where it says she pretended to throw up on the stand that day, and that was my thought exactly because I have a gag reflex. I really do when someone is literally getting sick. She was going through the motions. She was making particular sounds, but that's all there was to it. She was faking it, kind of like when you watch her when the police come, when they've called the police because they found him deceased, and she just is not a good. She's no good at acting out as though she's got human emotions. That would be the best way to describe it. She was trying to act as though she were crying and upset, yet her face never got red. She never had one tear, and she could be moaning and whining and, supposed crying, and the police officer would ask her a question. In a normal voice, she would respond, and then she would go back to her um, behavior of pretending again. So it's a shame. I do understand the rights and the protection that people get when they're convicted. But in a situation like this, in a situation where it is an absolute slam dunk case, I just don't see why they're allowed to keep it up, to waste the money, waste the court's time, and drag people through another trial. So, this is a trial to see if there was any wrongdoing, to see if she deserves a second trial. And no, she doesn't. So, and I guess, to those that are attorneys or whatever, I guess that everybody will probably believe that, this is the right way to do it, appeals and all that. But really and honestly, when you have somebody dead to rights that has taken someone's life or anything, when you have video showing somebody doing something and they're convicted, and then for whatever reason they get to appeal because there might be some little loophole somewhere, I have a real problem with that. And when people get off because of those little loopholes, people, are what? They're not protected anymore. It's kind of a dangerous situation to be in. So, um, I'm sure that, um, I mean, I'd be happy to play the rest of this hearing if anyone is interested, but it would be, you know, a part three because it's kind of drawn out. And mind you, this was a whole day for them, but they spent so much time trying to figure out whether Shanda could testify, whether Shanda could go on, if they needed to, not do it. And hopefully when they bring her back for the next one, the next day, they give her double medication or whatever for car sickness and headaches, and just slam the drugs down her throat that she needs so that she can't get there and say, "Oh, I'm car sick," because you do feel kind of crappy when you're car sick. You do. But it doesn't, I mean, big deal that she felt ill from being car sick. I mean, I could care less, actually, compared to what she did to Timothy. I mean, that's nothing. It's not even, I mean, it's absolutely, it really is nothing, right? So, to me, she's just a monster that was walking among us. And it would be so interesting to find out what her older children knew, because the way those 2 older children spoke of her and Paul, there was some situations, I bet. Shanda didn't just start this. She didn't just start acting this way. And, I don't know why we didn't see the biological father. You would think that, well, maybe he was afraid that he would be in trouble for sending Timothy to his mother, since she was forbidden to have any, she wasn't allowed to see him without supervision. That was the court order in Oklahoma, but once she moved and she's in different jurisdictions and different places, and you know I have no idea what his biological father was like, but because of the fact the other children were put in foster care, I'm going to assume neither one of them should have been having children. That's just my guess. Excuse me. So, I hope that y'all have enjoyed this opinion presentation of Miss Shanda Vander Ark. And I've got more coming, but I I don't, I'm not going to show the entire trial that was on Wednesday unless somebody says they want me to. I may go in and get bits and pieces of it, but I did want to show her attorney. I wanted to show his testimony because no one watching this gentleman could even fathom that he didn't care. He's probably the only person who really wanted to help this lady. I think everybody else was just sickened by her. And, she even mentioned that her father in law was an attorney. I bet he was really sickened by her. So I just don't get why she's allowed to clog up the courts. But like I said, everybody that's convicted, they have all these appellates things that they do, and they're just looking for anything, any little thing that they can use in order to get the verdict turned over or to get a new trial. And really wish that just wasn't the case. I mean, there's times that people actually do need to appeal something. I get that, but it shouldn't just be the norm. But I'm sure an attorney could point out why it is the norm. I mean, brother counsel, I love him. He's so cool. Maybe he could answer that. Maybe he could answer that. I like brother counsel. Um, Anyway, I'm gonna go ahead and bid y'all good night. I hope you have a wonderful day. Monday is coming right after the holidays that people have been off. I've got to get my shopping done. Haven't even started. So usually I'm done, but for some reason this year's just been. And hopefully, well, I go to the doctor tomorrow for my little trigger finger, and we'll find out. I don't know if they're going to fix it tomorrow or schedule to fix it tomorrow. But I'm a little nervous about it. I mean, the pain when I hit it is hurts. So I really can't imagine them messing with it, but I guess you got to do what you got to do to get it fixed, right? Because it's really hard to do everything when I'm right-handed and it's my right thumb and all that. So y'all have a great day, and I hope to have a video. I'm not sure what it will be on, but I'm gonna try for the next week, 2 weeks, to get one out every day. I think, I'm just gonna stop worrying so much about everything I worry about. I enjoy doing them. I'm gonna do them. I'm gonna post them, and that's just, yeah, I'm too old to go into all this research and to. Bottom line is, I just am me, and I'm just going to remain that. All right, and I do still have a lot of things that I have got to say about the Karen Reed situation. Um, I'm in awe that the McAlberts think that they can convince anyone that they were harassed or victims. When you're being told to tell the truth, that's not really harassment. And this they need to separate. If they want to, go after Karen Reed for anything they want to claim she did is one thing. And if they want to go after Turtle Boy, that's another thing. But they need to stop putting they need to stop trying to combine it because Karen Reed has no control over Turtle Boy and what he says or does. The fact that she gave him information as one would give a journalist as she would have given to another journalist. Mainstream media had anybody given a flying flip, but nobody did. Only Turtle Boy seemed to care about the situation and getting the truth out. So that's something that we'll all remember. Um, I mean, like I said, I watched the trial because of Emily D. Baker covering it, and I was curious. I went in, and that's how I found it. But I wish they would just leave her be. Just leave her be. Just leave it all. Just let it all. I mean, science didn't lie. And that doctor that was on the stand that just says, well, he wasn't hit by a car and he did not die from hypothermia. She seems to be one of the better docs I've seen. I love that lady. She's so smart. The way she describes everything to where you can completely understand it was so cool. So, yeah, I've got a lot to say about that. But I'm also still, there's a lot to say about Shanda. I want to find some of the earlier interviews and cover those because there's a lot that I didn't look at that now, because of her appeal, I'm going back to look at some stuff. And hopefully, I don't see anything that really just does me in. So, y'all have a great night. I hope you enjoyed it. Leave me a comment if you want me to cover the rest of it or your opinions. I mean, just say something. I will reply. It may not be super fast, but I will get to it. Have a good night.